Hi, I'm Greg Dell with Dell Disability Lawyers here with Stephen Jessup, and we're going to talk a disability benefit tip video here about how do you fight a long-term disability denial. And Stephen, I say fight because unfortunately it's a battle. I mean, a disability insurance company just came to the claimant and said, we think you can go back to work, whether it was what you used to do or in any job. And a lot of times people get this letter, totally unexpected. It could be either they never got approved, or like a video we did earlier this day, it could have been someone who was approved for 22 years. And all of a sudden you get a letter and it says, you can go to work, you're not disabled anymore. So what's the first thing that someone needs to be, what are the first steps that you take in terms of how to fight this denial?
It starts with the denial letter, because generally speaking, the denial letter is going to give you a roadmap of how the insurance company's thinking, what reviews they conducted, who they had look at the file, and what those opinions are. Now, we do see some denial letters that are very one page and have really no information. But generally speaking, the denial letter is going to give you an idea of what you're going to need to do from a strategy standpoint to attack their position and undermine what their opinion really is. So the denial letter, first and foremost, is really one of the most helpful tools that you have as an insured of understanding, all right, this is what I'm up against, this is what they think, what can I prove or show them how they're wrong. So that's for an insured. And then when we see it, obviously we have enough experience dealing with these insurance companies for so long, and every company has various nuances, but there's always the same kind of situations. You can apply a similar template back to them and what you may need to do in supporting and showing what's in the appeal. So really getting that denial letter, and some people, they want to jump and they want to file their appeal immediately because it says, or if they get a call, sometimes they say, well, you can just submit an appeal, just write a letter saying you disagree and you want to appeal. Or some insurance companies give you a one-page form for your appeal to fill out and submit back to them. So the first thing to do is, yes, there's that shock of the denial, but really take a breath. And don't act too hasty in it, because in some situations you're only going to get one shot to appeal it. I think at that point it's a good idea to contact a lawyer to really discuss, because this is new for everyone. If you're sick and you're not able to work, you have an insurance policy, and how many times we hear where they say, I paid for the premiums, I expected I would get the policy, I can't believe they do this, how could they do this to me? And I always tell people, I know it's personal to you, but they do this to everyone. There's strategies they have in place. So the more you can understand that, the better, as the individual, the insured, can also navigate the denial.
Okay, so the denial letter is essential, and some of the carriers call you and say, we're calling to tell you that we don't find support for your claim and you'll be getting a letter. And a lot of people call us before they even get the letter, but we really need the letter to review it, because the law requires them, whether it's an ERISA-governed claim or an individual disability claim, to provide a reasonable written explanation as to the basis for their denial. It doesn't always do that, as you touched on a minute ago, but it's enough to just see what's going on. But after that, and 90% of these claims are employer-provided policies, which means you have it as a benefit from your employer, and if you got the policy from your employer, then it's governed by a law called ERISA, and we've done other videos where we talk about what ERISA is. But if the claim is employer-provided, and maybe even if it's not employer-provided, most of the disability companies will provide what's called the claim file. Can you explain what that is and why it's so fundamental to do a deep dive into the claim file in order to form a good strategy to fight a long-term disability denial?
Yeah, the claim file is everything about you. Anything you've submitted to the insurance company regarding your claim, maybe what your employer submitted, and anything that the insurance company's created as part of its review. So in those denials, the denial letter will talk about, we had this doctor look at it and that doctor, and we did a vocational analysis. Well, all those reports are going to be in the claim file. So before you even issue a response, appeal letter, you want that so you can see exactly what their doctors are saying. Find if there's any video surveillance. And there's times that we go through a claim file, and what the insurance company's trying to argue their own doctor's opinions are, when you really look at those reports, the reports are actually in favor of an insured in a lot of ways. So there's real good nuggets that can be had. So that claim file is really, if this is you think about like a board game, that's going to have every single rule, every piece of information you're going to be able to do to execute your mission.
Is there other evidence that's not in the claim file that could be used against the claimant?
that they don't turn over.
Right.
You know, it depends on some, like you had mentioned with individual disabilities. Sometimes they'll argue that it's work product or certain, private sensitive information or internal guidelines, so they won't submit that. But for all intents and purposes, the information you're going to need is going to be in that claim file. All their medical reviews, if they did surveillance, vocational reviews, things along that line.
Okay, so you get the denial letter, you get the claim file, you do a deep dive into it. Then, even though the claim file is supposed to have everything the disability insurance company got, the next step is to get all of the medical records from the past to the current. And why is that so essential?
Because especially since we're talking about the vast majority are going to be ERISA disability cases, you're only going to get generally one chance to appeal this and provide all the information. And I don't take it upon an insurance company to have gotten all your medical records. You know, people say all the time, oh, the insurance company had the authorization to get my records. Why didn't they? They used to. And I remind people that ultimately, if this goes to court, you have the duty to provide proof of loss, the information that supports you're disabled, and that's your medical record. So in reviewing everything, you want to look at how a judge may look at this. You work backwards from what the end results could be and build up all the pieces of information that you want. So generally, if someone hires me, the first, as soon as I get a contract back that they hired me, I shoot out a letter of representation requesting the claim file, and I ask the client, please provide me with a list of all the doctors you've seen, generally for about 3 years, from the date prior of the date of denial, the date of disability, whatever the case may be, and we immediately start getting those records. So we can start getting those records prior to the claim file, because the insurance company will have about 30 days, to get you a claim file. So trying to be one step ahead of them. So getting your medical records is key, not only because they may not have them, but the biggest aspect of success in a claim is what's in your medical records, the documentation,
Right.
the paper.
So going from the importance of getting the medical records, what I always tell claimants when they call us is that writing the appeal is probably 25% of this. When I say writing the appeal, because at the end of the day you have to submit them something, a letter, documentation. But our strategy at our law firm as long-term disability lawyers that have literally handled thousands of long-term disability appeals and denials is it's all about in building additional evidence in support of disability. So explain what that means and how you go about doing that in general terms, because obviously for every medical condition there's a different strategy, and based upon what you see in the claim file there's a different strategy, and based upon policy language there's a different strategy. So how do you, is it the same for every claim? I mean, what do you go about doing to actually build additional evidence in support of disability?
It really starts with the diagnosis. Like you said, there's so many different medical conditions that can result in disability, but starting with the diagnosis, understanding what the condition is, what the problems can arrive from that condition, be they cognitive, psychological, physical, whatever the case may be. And then once you have that is the rock by which you build your evidence. You go, oh, if it's a physical problem and they're saying, well, we have no evidence of restrictions and limitations, do we look at functional capacity testing? If someone's complaining that they can't concentrate and they're having issues remembering, neuropsychological testing. So from the diagnosis, we're able to determine what type of additional information, as objective as possible, can we provide to the insurance company to show, not that you have your medical condition, because the argument from the insurance company isn't going to be, generally at least, we don't believe you have a medical problem. They're going to acknowledge the diagnosis, and their argument is the nuance is, we just don't think it results in impairment that would prevent you from working. So it's creating the information that draws that nexus, that shows the impairment due to the medical condition. So it really starts with the diagnosis there. And I think it's also very important to really focus on facts, what you can show, what you can prove. With appeals, like you said, the appeal letter is maybe 25% of it. I try not to be overly argumentative in insurance company, you didn't do this and you didn't do that and X, Y, and Z, because I know if I submit the appeal with that and they go back and they do all those things and still end up with a denial, if I'm thinking about how I'm going to present this in court, I've just lost a lot of arguments I can make to a court. So it's really, really fact driven. It's a very emotional time for people being on disability and being denied, but you have to try to keep it as logical and fact-oriented.
So most appeals, whether it's a private claim or again an ERISA-governed employer-provided claim, they give you at least 6 months to submit an appeal. And some people go, why do I got to wait 6 months, or why so much time? I mean, they just denied me. I can't go another 6 months without benefits, plus they're going to take 45 to 90 days to review the claim. What are you doing as an attorney preparing an appeal during the 6 months that they give you in order to submit a really strong appeal?
Yeah, so generally, you have the 6 months, and if you need the 6 months, take it, because it could be, especially under ERISA policies, your only opportunity to present additional information. That could be it for you. So during that time, it is. If the person, for instance, hasn't been going to a doctor, hasn't seen a specialist for the condition, if the medical records are weak, we need them to get built up. If there's objective testing they could get, for instance, if they have back problems, new MRIs, EMG and nerve conduction studies. So those are things that can take a while to get scheduled for the client, for them to be able to go in and get. So that can be, taking that additional time. And then also other testing we may want to do. It can take some time to be able to coordinate all that stuff. You could easily turn around and argue, and people say, oh, I can't wait 6 months, and I understand that, but that 6 months could represent 10, 20, 30 years of potential benefits. So you have to be very cognizant of the long game, because they're hoping you rush into it.
And in terms of building evidence, which are these tips we're providing, how closely do you work with the claimant's treating doctors to get additional medical evidence and support a disability?
As much as they possibly will. Some doctors are very, very helpful. Will write amazing, elaborate letters of explanation, review the insurance company's reports and attack them. And then, we do unfortunately run into where doctors just don't want to get involved. Or they even tell the client up front, I don't fill out paperwork for insurance companies. So as much as a doctor will be willing to assist, I'm all about it. And then what I also try to do to make it easier for the doctor is, if there is information, for instance, if we have a physical pain condition, maybe a back problem, for instance, getting that functional capacity evaluation, well, if that comes back in favor, saying that the person's not going to have the capacity to work, that makes it easier for a doctor then, in filling out anything or completing any questionnaires, to be able to rely on that. So you're making the job easier. And another thing I also like to let doctors know, especially under the employer-provided ERISA policies, since in court they're not going to testify, they're not going to be deposed, I remind them of that. Because I think a lot of times doctors may get scared and think, well, I don't want to get pulled from my practice, have to deal with defense attorneys and insurance companies, I just don't want to deal with the headache. I let them know, hey, the only thing that may ever come before a judge's eyes are your medical records and written opinions. You're never going to be deposed, you're never going to testify, and I find sometimes the doctors will then become more willing to assist in completing, questionnaires, forms, rebuttal letters, all that, all those things.
And it's really hard for a claimant to go to the doctor and say, can you write a letter for me in support of disability? Because most of the doctors don't even know where to begin. It's not something they do. They hate insurance companies because the insurance companies are nickel and diming them in their payments for fees. But they don't know the language of the policy. They don't know if they say you can sit for an hour or 4 hours a day or 10 hours a week, if that's going to hurt the claim or help the claim. So I know a lot of times we will prepare statements specific to the medical condition and ask kind of check the box questions for the doctor, which we know the disability insurance company has to see in order to find support for disability. So it's kind of like a quasi deposition that we take of the doctor, but it takes the doctor 5 minutes to complete. And the doctor loves that, because they're like, yeah, look, you're guiding me into what I need to opine on, and I don't have to go back and spend an hour, hour and a half figuring out to write a whole letter. If I know my patient, I know the chart, I know from seeing the patient for years or however long it's been, if I answer this questionnaire and this is what you need answered, then here's all the evidence. Because in a lot of these ERISA claims, the doctor will never testify, as you said, so there's no day in court. And this is the only way you can get your evidence out there. And so the evidence is the most important thing. And then there's vocational evidence. We were talking about medical. Talk briefly about how you have to provide vocational evidence to support the claim as well to reverse a denial.
So the vocational evidence is simply what your job entails, or if you're under any occupation definition, what your transferable skills are. So you're building the medical information to show how you would not be able to do from a vocational standpoint the material and substantial duties of your job, or how the definition of disability is going to define that. And there's are going to be standardized, formats for that. The Dictionary of Occupational Titles, ONET, and some of these other resources the Department of Labor created, so you can work those as templates, because that's what the insurance company is going to do. Because most of the times they're looking at your job, not how you performed it for your employer at your location, but how it's generally performed in the national economy. So you're just building that medical information to be able to basically X out and show how you're not able to do these duties, or maybe you're not able to do them on a full-time basis type situation.
Well, we've talked a lot about the appeal strategy, and of course, if you lose the appeal, the next step is to file a lawsuit. And we have lots of other videos talking about lawsuits against disability insurance companies and what to expect. And we also have lots of videos specific to all of the major disability insurance companies and strategies to take in lawsuits. So I highly recommend that if you're interested in that and you're at the stage now where you need to file a lawsuit, that you check out our other videos or call Steven, call myself. We've filed lawsuits against every disability insurance company. We always provide an immediate free consultation no matter where you live, and we look forward to the opportunity to help you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.